Legal disclaimer. The following content involves complex matters regarding United States labor law, employment regulations, and workplace compliance. This presentation is strictly for educational and entertainment purposes only. It does not constitute legal advice, attorney-client privilege, or professional counsel. Employment laws in the United States are subject to extreme variation depending on jurisdiction, specifically differing significantly between federal statutes and individual state regulations. A right that exists in California or New York may not exist in Texas or Florida, or it may apply differently based on the size of the employer, the specific industry, or the existence of a collective bargaining agreement. Furthermore, laws are subject to change through new legislation or court rulings. If you are currently facing a workplace dispute, wrongful termination, discrimination, harassment, or wage claim, you must conduct your own due diligence and consult with a qualified labor attorney or employment law professional licensed in your specific jurisdiction. By continuing to watch, you acknowledge that you are responsible for your own career decisions and legal actions. There is a silent epidemic costing American workers over $50 billion every single year. That is not a typo, and that is not an exaggeration. To put that number into perspective, that is more than the combined value of all bank robberies, convenience store holdups, and street thefts in the United States. It is called wage theft, and it is happening right under your nose, perhaps even on your next paycheck. But the money is just the tip of the iceberg. We are living through one of the most volatile employment markets in history. From the rise of quiet firing to mass layoffs handled via automated email, the traditional social contract between employer and employee has fundamentally fractured. Here is the terrifying reality that most human resources departments will never tell you. The average American employee is walking through a minefield blindfolded. You likely believe that if you are good at your job, show up on time, and meet your KPIs, you are safe. You believe that fairness is a legal concept. It is not. In the United States, the default standard is at-will employment, a term so widely misunderstood that it has cost millions of workers their livelihoods and their dignity. Most people interpret at will to mean, I can be fired for any reason. While technically true on the surface, this oversimplification is dangerous. It convinces you that you have no leverage. It convinces you to stay silent when you are asked to work off the clock. It convinces you to sign severance agreements that strip away your right to sue before you have even spoken to a lawyer. Consider the story of a mid-level manager we will call Alex. Alex worked for a major tech firm for 7 years. He was a top performer. When his company underwent a merger, his role was shifted. He was suddenly asked to perform tasks that were physically impossible within a 40-hour workweek. Yet he was classified as salaried exempt, meaning no overtime pay. He burned out, his performance dipped, and he was placed on a performance improvement plan or PIP. Alex thought the PIP was a tool to help him get back on track. He signed every document they put in front of him. He admitted fault in writing. 2 weeks later, he was terminated for cause, denied unemployment benefits, and left with zero severance. Alex did not know that his reclassification as exempt might have been illegal under the Fair Labor Standards Act. He did not know that the PIP was likely a paper trail designed to justify his firing, not to save his job. He did not know that by signing those admission documents, he was effectively handing the company the legal ammunition they needed to crush him. Alex lost tens of thousands of dollars in potential back pay and benefits, not because he was a bad employee, but because he did not understand the rules of the game he was playing. This is not just about Alex. This is about you. Whether you are an entry-level associate, a mid-level manager, or a senior director, the corporate machine is designed to protect itself, not you. The handbook you were given on your first day? That was written by lawyers to minimize the company's liability. The open door policy? That is often an intelligence-gathering mechanism to identify disgruntled staff before they become a legal threat. The problem we are solving today is the asymmetry of information. Your employer has a team of legal experts, HR consultants, and payroll specialists whose entire job is to navigate these regulations to the company's benefit. Who do you have? Until now, you likely relied on Google searches, hearsay from coworkers, or gut instinct. In a high-stakes professional environment, relying on gut instinct regarding legal rights is a recipe for financial disaster. This masterclass series is designed to level the playing field. We are not here to give you generic advice like, read your contract. We are going to deconstruct the specific, federally protected rights that supersede company policy. We are going to look at the mechanisms of power in the U.S. workplace. You need to understand that federal law is the floor, not the ceiling. You need to understand the difference between an uncomfortable work environment and a legally hostile one, because the distinction can mean the difference between a massive settlement and a dismissal of your case. We are going to dive deep into the specific statutes that protect you from retaliation. Retaliation is the #1 most frequently filed charge with the Equal Employment Opportunity Commission. Why? Because managers often take things personally. If you raise a concern about safety or pay, and suddenly your shifts are cut or you are moved to a basement office, that is not just office politics. That is illegal retaliation, and it is actionable if you know how to document it. This series will serve as your comprehensive dossier on workplace survival. We are going to move beyond the basics of minimum wage and look at the nuances of the National Labor Relations Act, which protects your right to discuss your pay with coworkers, a right that many employers actively try to suppress. We will explore the Family and Medical Leave Act, not just as a concept, but as a rigid legal procedure that you must execute perfectly to protect your job during a health crisis. The promise of this deep dive is simple: empowerment through actionable intelligence. By the time you finish this series, you will view your employment not as a passive state of being, but as a contractual business relationship where you hold significant cards. You will learn to recognize the red flags of a rights violation before it destroys your career. You will learn the specific language to use in emails to create a protected activity paper trail that makes it incredibly risky for a company to fire you. We are shifting your mindset from employee to business of one. When you understand your rights, you stop asking for permission to be treated fairly, and you start navigating your career with the confidence of someone who knows exactly where the lines are drawn. This is about protecting your income. This is about protecting your professional reputation. This is about ensuring that when you trade your time for money, you are getting every single cent and every single protection you are owed under the law. We are about to walk through the 5 most critical, yet commonly violated workplace rights in the United States. These are the rights that bad managers hope you forget. These are the rights that can save your career when the walls start closing in. This is not just a video. This is an investment in your professional future. We are going to dissect the legal framework, examine historical case studies, and provide you with a step-by-step mental framework for every scenario. Do not skip a second of this, because in the world of employment law, what you don't know can and will cost you everything. The deep dive begins now. Right number 1. The right to discuss your wages. This is arguably the most pervasive myth in the American corporate landscape. You have likely sat in an orientation meeting, or perhaps you were skimming through a 50-page employee handbook, and you saw a clause that looks something like this: employees are prohibited from discussing their compensation with coworkers to maintain workplace morale and privacy. Or maybe a manager pulled you aside after a meeting and whispered, "Keep your bonus number to yourself. We don't want to cause jealousy among the team." That instruction, whether written in a glossy handbook or whispered in a hallway, is frequently illegal. In the United States, under the National Labor Relations Act, or NLRA, enacted in 1935, you have a federally protected right to discuss your wages, benefits, and working conditions with your colleagues. This is not a new law. It has been on the books for nearly a century, yet it is violated with staggering frequency. Let's dismantle the pay secrecy trap. Most employees operate under the assumption that their salary is a trade secret owned by the company. This is a psychological barrier constructed by employers to maintain information asymmetry. If you do not know what your peer is making, you cannot negotiate effectively. If you do not know that the new hire, who has half your experience, was brought in at a 20% premium, you will not demand a raise. Silence is profitable for the employer. But under Section 7 of the NLRA, this silence cannot be enforced for non-supervisory employees. This protection falls under what the law calls protected concerted activity. This is a critical legal term you need to burn into your memory. Concerted means acting together. When you speak to a coworker about your salary, you are theoretically taking the first step toward collective bargaining or mutual aid. You are gathering data to improve your working conditions. Even if you are not in a union, and even if you have no intention of starting a union, Section 7 protects you. The National Labor Relations Board, or NLRB, has consistently ruled that policies prohibiting salary discussions are unlawful because they chill this protected activity. Imagine a scenario involving an employee named Marcus. Marcus works in logistics. He suspects he is being underpaid relative to the market rate. During a lunch break while off the clock, he asks his colleague, "Hey, did you get that 3% cost of living adjustment?" I only saw 1%. A supervisor overhears this. Later that afternoon, Marcus is called into the office and written up for unprofessional conduct and creating a hostile work environment by discussing private matters. In this scenario, the company has likely broken federal law. The hostile work environment claim is often used as a smokescreen to shut down uncomfortable conversations. However, the law is nuanced. You must understand the specific mechanics of how this right works to use it safely. The protection generally applies to conversations that happen when you are not strictly required to be working, such as break times, lunch hours, or before and after shifts. However, if your employer allows employees to talk about non-work topics like the Super Bowl or their weekend plans while working, they typically cannot single out wage discussions for prohibition. That is discriminatory enforcement. There is, however, a massive exception that trips up thousands of people: the managerial exception. The NLRA applies to employees. It does not protect supervisors. But here is where it gets tricky: job titles are often inflated. Just because your business card says manager does not necessarily mean you are a supervisor in the eyes of the NLRA. To be excluded from protection, you generally must have the authority to hire, fire, discipline, or responsibly direct other employees using independent judgment. If you are a social media manager, but you have no direct reports and no authority to fire anyone, you are likely still protected by the NLRA. Companies often inflate titles to trick employees into thinking they have lost their rights. Do not fall for the title. Look at the authority. Let's look at the data on why this matters. Pay transparency is the single fastest route to closing wage gaps. Historical trends show that when salaries are transparent, the gender and racial wage gaps shrink significantly because bias has nowhere to hide. When salaries are secret, bias thrives in the dark. By enforcing pay secrecy, companies are not just protecting morale, they are often protecting a chaotic and unfair compensation structure that would collapse under scrutiny. Furthermore, this right extends to social media. In the digital age, the water cooler is often a Facebook group or a Twitter thread. The NLRB has issued decisions protecting employees who discuss working conditions on social media platforms, provided the speech is not egregiously offensive or knowingly false. If you post, "I can't believe they are paying us $15 an hour when the shop down the street pays $20," that is likely protected concerted activity. If the company fires you for that post, claiming you violated a social media policy regarding company reputation, they may be liable for wrongful termination under the NLRA. However, we must address the how. Just because you can do something doesn't mean you should do it recklessly. Navigating this right requires tactical emotional intelligence. If you storm into a meeting and demand everyone shout out their salaries, you might be disciplined for disruption, not for the content of the speech. The key is context. The conversation should be framed around mutual aid. I am trying to understand if we are being paid market rate, so we can all advocate for better adjustments. This framing reinforces the concerted nature of the activity. You also need to be aware of the access exception. If your job involves handling payroll or HR records, for example, if you are an HR assistant or a payroll clerk, you generally do not have the right to share other people's pay information that you learned through your confidential job duties. You can share your own, but you cannot leak the CEO's salary if you found it while processing checks. That is a breach of duty and is a fireable offense. Let's deepen the analysis with a what-if scenario regarding retaliation. Suppose you discuss wages and suddenly your shifts change. You aren't fired, but you are given the Clopen shifts, closing late at night and opening early the next morning. This is a classic soft firing tactic. Retaliation is illegal, but proving it requires documentation. If you exercise your right to discuss wages, you must simultaneously start a paper trail. Document who you spoke to when and exactly what was said. If your manager makes a comment like, "We don't like troublemakers who talk about money," write that down immediately with a timestamp. That comment is the smoking gun in an NLRB complaint. The penalties for companies violating this are, admittedly, often weak, usually involving posting a notice and providing back pay for wrongfully terminated employees, which is why many companies take the risk. They calculate that the cost of a lawsuit is lower than the cost of raising everyone's wages to a fair level. This is why you must be the enforcer. You cannot wait for the government to step in. They are underfunded and overworked. You have to know the line so you don't cross it, but you also have to know when your employer has crossed it. We have established that you have the right to know what your labor is worth by comparing data with your peers. But knowing your worth is useless if you don't understand how your time is actually calculated. This leads us to a much darker, more complex area of labor abuse. It involves the silent theft of time, the misclassification of your very identity as a worker, and a legal loophole that costs Americans billions. You might think you know what overtime means. You might think that because you are on a salary, you are not entitled to extra pay when you work 60 hours a week. You are likely wrong. There is a specific, federally mandated test that determines if your boss owes you thousands of dollars for those late nights, and it has nothing to do with whether you agreed to a salary in your offer letter. In the next section, we are going to expose the exempt versus non-exempt scam and reveal why your job title might be a lie designed to steal your wages. Right number 2. The right to overtime pay and the exempt classification trap. This is the single most financially devastating misunderstanding in the American workforce today. There is a prevalent belief that as soon as you move from hourly to salary, you have made it. You get a consistent paycheck, maybe a shiny new job title, and you feel like a professional. But for millions of Americans, accepting a salaried position is not a promotion. It is a mathematical demotion. It is a strategic maneuver by employers to cap your labor costs while uncapping your workload. Here is the hard truth. A salary is not a license for your employer to own your time 24/7. The Fair Labor Standards Act, or FLSA, is the federal law that governs this, and it is far more rigid than your boss wants you to believe. The default assumption under U.S. law is that every employee is entitled to overtime pay at a rate of time and a half for every hour worked over 40 in a work week. To strip you of that right, your employer has to prove that you fit into a specific exemption. This is where the terms exempt and non-exempt come from. Exempt means you are excluded from overtime protections. Non-exempt means you get paid. Companies often act as if they can simply choose which one you are. They cannot. Your status is determined by law, not by your manager's mood or your job description. To be legally classified as exempt, your role generally must pass 3 strict tests: the salary basis test, the salary level test, and the duties test. If you fail even one of these, you are likely non-exempt, and you may be owed thousands in back pay. Let's look at the salary level test first. This is a hard number. The Department of Labor recently updated these thresholds, shaking up the entire industry. As of mid-2024 and moving into 2025, the threshold for exempt status has increased significantly. If you are making a salary below the current federal threshold, historically around $35,000, but jumping to nearly $44,000 and eventually over $58,000 in recent updates, you generally cannot be exempt regardless of your job title. You could be the supreme commander of operations, but if your salary is $40,000 a year, you are likely entitled to overtime pay for hour 41. Check the current Department of Labor threshold for the specific date you are watching this, because if you are under that line, the conversation is over. Pay me. But the real fraud happens in the duties test. This is where the gray area destroys work-life balance. Employers love to give out inflated titles to bypass this test. They call it title inflation. A classic case study involves the assistant manager loophole, commonly seen in retail and fast food. Imagine David. David works at a coffee shop. He is promoted to assistant store leader. He is put on a salary of $60,000 a year, which sounds great compared to his hourly wage. But now David is working 60 hours a week. He spends 90% of his time making coffee, sweeping floors, and stocking shelves, the exact same work as the hourly baristas. He only spends 10% of his time managing, maybe doing the schedule or counting the till. Under the FLSA executive exemption, to be exempt, your primary duty must be management. You must customarily direct the work of 2 or more full-time employees. And this is key, you must have the authority to hire or fire, or your suggestions on hiring and firing must be given particular weight. If David is just a glorified barista who holds the keys but has no real authority, he is likely misclassified. Let's do the math on David's promotion. At $60,000 a year working 40 hours, he earns roughly $28.85 an hour. But David works 60 hours. If he were hourly, those extra 20 hours would be at time and a half. By paying him a flat salary, the company is effectively getting 20 hours of free labor from him every single week. Over a year, that is over 1,000 hours of unpaid work. The company just saved tens of thousands of dollars by giving him a $2,000 raise and a fake title. This is wage theft, plain and simple. Then there is the administrative exemption. This is the catch-all bucket for office workers. To qualify, your primary duty must involve office work directly related to management or business operations, and crucially, it must involve the exercise of discretion and independent judgment with respect to matters of significance. This is the secretary trap. If you are an administrative assistant who simply follows a handbook, types emails exactly as dictated, and books travel according to a strict policy, you are likely non-exempt. You are not exercising independent judgment on matters of significance. You are following protocol. Yet, millions of office workers are told, you're on salary so you have to stay until the job is done, even when the job is routine data entry. Consider the modern digital sweatshop. The FLSA was written in 1938. It did not anticipate smartphones. Today, the workday rarely ends at 5 p.m. If you are non-exempt hourly, and your boss texts you at 8 p.m. asking where a file is, and you spend 15 minutes finding it and replying, that is compensable work time. If you are required to check Slack notifications on the weekend, that is compensable work time. There is a terrifying concept called de-minimized time, trivial amounts of time that courts use to ignore. But as digital intrusions grow, these minutes add up. If you spend 15 minutes every night answering emails, that is over an hour a week or 60+ hours a year. That is a week and a half of pay you are donating to a company that would fire you to save a penny. The Department of Labor has been cracking down on this. If you are hourly, do not work off the clock. Ever. If you are asked to document the request, just to clarify, you want me to handle this client call at 7 p.m.? Please confirm I should add this to my timesheet. Watch how fast the request is withdrawn. This also applies to volunteering. Your employer cannot ask you to volunteer to do your normal job. If you are an accountant, you cannot volunteer to do the company's taxes on the weekend. If you are a nurse, you cannot volunteer to take a shift. Legitimate volunteering is for nonprofit, charitable, or humanitarian purposes, not for increasing shareholder value. So, how do you audit yourself? First, find your official job description. Second, track your actual hours worked for 1 month, including all those quick emails at home. Third, compare your actual duties to the Department of Labor fact sheet #17A. Executive, administrative, professional exemptions. If there is a mismatch, if you are doing grunt work but paid a manager's salary, you have leverage. Case studies have shown that class action lawsuits regarding misclassification are among the most successful types of employment litigation. Companies like Uber, FedEx, and major retail chains have paid out millions because they tried to get cute with these definitions. But remember, the burden of proof often starts with you. You need a log of your hours. You need a log of your duties. But what happens when the workload becomes too much? We have talked about pay and we have talked about hours. But the human body has limits. When you are working those 60-hour weeks, stress accumulates. Immunity drops. Illness strikes. Or perhaps a family member falls critically ill, and you are the only one who can care for them. This brings us to a moment of absolute vulnerability. You are sitting in a hospital waiting room, terrified not just for your health, but because you think your job is gone. You think that because you missed a week of work, you have been abandoned your position. You think you have no choice but to rush back to the office while you are still sick. You are wrong. There is a federal shield designed specifically for this nightmare scenario. It is a break glass in case of emergency law that can force your employer to hold your job open for months, even if they hate doing it. But, and this is a massive but, it is not automatic. You have to trigger it with specific notification procedures. If you don't say the right words within the right time frame, the protection vanishes. In the next part, we are going to unlock the medical fortress. We will explain exactly how to freeze your employment status in time, keeping your benefits alive and your chair empty until you return, using a law that many HR departments pray you don't understand. Right number 3, the Family and Medical Leave Act, or FMLA. This is your medical fortress. In a country that notoriously lacks universal paid sick leave, the FMLA is the closest thing American workers have to a federal safety net for health crises. It is the legal mechanism that prevents your boss from firing you because your spouse, your child, or your parent got sick. It freezes your professional existence in amber for up to 12 weeks a year. But here is the critical distinction that catches millions off guard. FMLA is about protection, not payment. It saves your job, not your paycheck. The FMLA provides eligible employees with up to 12 work weeks of unpaid, job-protected leave per year. It also requires that your group health benefits be maintained during the leave. Essentially, the company has to keep paying their share of your insurance premiums as if you were sitting at your desk. If you have ever wondered why a coworker disappeared for 2 months and then walked back in as if nothing happened, this is likely the law they used. But the FMLA has gatekeepers. You do not just get FMLA. You have to qualify for it, and the criteria create a rigid iron triangle of eligibility. If you miss even one of these 3 metrics, you are exposed. First, the tenure test. You must have worked for your employer for at least 12 months. These do not have to be consecutive months. If you worked there in 2019, left, and came back in 2023, the prior time can often count towards the 12 months, provided the break in service was less than 7 years. Second, the hours test. You must have worked at least 1,250 hours during the 12 months immediately preceding the start of your leave. This is the math that destroys part-time workers. 1,250 hours averages out to about 24 hours a week. If you work 20 hours a week, you will hit the 12-month mark, but you will fail the hours test. You could be a loyal employee for 10 years, but if you only work 2 shifts a week, you have 0 federal FMLA protection. Third, the size test. Your employer must have at least 50 employees within a 75-mile radius of your worksite. This is designed to protect small businesses from the burden of holding jobs open. However, in the age of remote work, this is tricky. If you work from your home in Montana, but you report to a headquarters in Chicago that has 500 people, you are covered. Your worksite for FMLA purposes is the office to which you report. Do not let a manager tell you that because you are the only remote employee in your state, you don't qualify. That is often false. Now let's unlock the intermittent leave secret. This is the aspect of FMLA that HR departments often dread because it is an administrative nightmare for them, but a lifesaver for you. Most people think FMLA is for a sudden heart attack where you vanish for 3 months. It is also for chronic conditions. Imagine Sarah. Sarah suffers from severe migraines that are unpredictable. Some weeks she is fine. Other weeks she needs 2 days in a dark room. Without FMLA, Sarah would be fired for excessive absenteeism within 6 months. But Sarah files for intermittent FMLA. Her doctor certifies that she will need episodic leave for flare-ups, perhaps 2 to 3 times a month. Now, when Sarah wakes up with a migraine, she calls in and states, "I am taking an FMLA day." That absence is now federally protected. It cannot be counted against her for attendance points. It cannot be used in her annual review to deny her a raise. It cannot be used as a reason for termination. She is essentially drawing down her 12-week bucket in 8-hour chunks. This transforms a fireable attendance problem into a protected medical accommodation. However, you must navigate the paperwork war. FMLA is not verbal, it is bureaucratic. When you notify your employer of the need for leave, they must provide you with a notice of eligibility within 5 business days. Then, you have 15 calendar days to return the medical certification form filled out by your doctor. If you miss that 15-day window, they can deny your leave and fire you for the absences. You must treat these deadlines with the same urgency as a court summons. Furthermore, understand the substitution of paid leave. Since FMLA is unpaid, how do you pay your rent? Most employers have a policy requiring you to use your accrued paid time off, PTO, concurrently with FMLA. They force you to drain your vacation and sick days while you are out. This is generally legal. You might want to save your vacation days for later, but the company can say, "No, you are on FMLA, you must burn your PTO bank first." The FMLA shield and the PTO money run at the same time until the money runs out. Then you are on unpaid FMLA. Let's look at the key employee trap. There is a tiny loophole where a company can deny reinstatement, not the leave itself, but the job upon return, to a key employee. This is defined as a salaried eligible employee, who is among the highest paid 10% of all the employees within 75 miles. If restoring you to your job would cause substantial and grievous economic injury to the operations of the employer, they can cut you loose. If you are a highly paid executive, you need to check if you fall into this top 10% bracket. They must notify you of this status before you take the leave. Now consider the return. You are entitled to be restored to the same or an equivalent position. Equivalent means virtually identical pay, benefits, and working conditions. It involves the same or substantially similar duties, privileges, and status. If you were a shift supervisor, and you come back and they make you a janitor with the same pay, that is likely an FMLA violation because the status and duties are not equivalent. However, if you were the manager of the Northside branch, and they bring you back as manager of the Southside branch. Same pay, same commute, same prestige. That is usually legal. You do not own your specific chair. You own your professional standing. What about retaliation? This is the most common battlefield. It is illegal to interfere with your FMLA rights or retaliate against you for using them. But employers are smart. They rarely say, "We are firing you because you took leave." Instead, they wait. You return from leave and suddenly your performance reviews tank. You are nitpicked for minor errors that were previously ignored. 3 months later, you are laid off due to restructuring. This is known as a pretextual termination. If you can show a temporal proximity, a closeness in time, between your return from leave and the adverse action, courts often view that as suspicious. This is why documentation is your lifeline. If you return from FMLA, you must be hypervigilant. Document every interaction. If your boss makes a comment like, "It's good to have you back. We really needed someone who is actually here," write it down. That implies animus against your legally protected absence. FMLA covers you when you are too sick to work, or when your family needs you. It is a powerful shield for absence. But what happens when you can work and you want to work but the environment itself is the obstacle? What if you don't need time off, you just need a change in protocol? What if you have a disability that requires a modification to your desk, your schedule, or your software, and your boss says, "We don't do that here"? There is another law, even more powerful than the FMLA in some respects, that forces companies to rewrite their own rules to keep you employed. It shifts the conversation from, "I need to leave" to "You need to change." In the next part, we are going to explore the Americans with Disabilities Act, and we will reveal why reasonable accommodation is the phrase that can force a corporation to buy you expensive equipment, change your start time, or even reassign you to a new job entirely, all to keep you on the payroll. This is where the law gets physical. Right number 4. The Americans with Disabilities Act, or ADA. This is the heavy artillery of employment law. While the FMLA allows you to leave the battlefield to recover, the ADA forces the battlefield to change so you can stay and fight. This is arguably the most powerful civil rights law in the workplace because it challenges the fundamental assumption that the employee must perfectly fit the job. Under the ADA, the job often has to fit the employee. There is a massive misconception that the ADA only applies to visible physical disabilities, wheelchairs, blindness, or hearing loss. This is false, and this belief keeps millions of Americans from accessing protections they already own. The definition of a disability under the ADA Amendments Act is intentionally broad. It covers any physical or mental impairment that substantially limits a major life activity. Major life activities include sleeping, concentrating, thinking, communicating, and regulating emotions. This means that conditions like severe anxiety, clinical depression, PTSD, ADHD, diabetes, epilepsy, and cancer are often covered. If you have a condition that affects your ability to sleep or focus, you are likely part of the protected class. But here is the catch. The ADA is not a magic wand that grants you immunity from firing. To use it, you must be a qualified individual. This means you must still be able to perform the essential functions of your job, with or without what is called a reasonable accommodation. Let's break down reasonable accommodation. This is the core mechanic of the statute. It requires employers to modify the work environment or the way things are customarily done to enable a qualified individual with a disability to enjoy equal employment opportunities. This is not a request for a favor, it is a request for a civil right. Consider the case of Elena, a software developer with severe ADHD. The open plan office is a nightmare for her. The constant noise makes it impossible to code. Her performance starts to slip. Her manager tells her she needs to focus better. Elena knows she can do the work if she has quiet. Without the ADA, she gets fired for poor performance. With the ADA, she requests a reasonable accommodation, noise-canceling headphones, and the permission to work from a quiet conference room or from home 2 days a week. This triggers a specific legal obligation called the interactive process. This is where the game is won or lost. Once an employee discloses a disability and requests an adjustment, the employer cannot simply say no. A flat denial without discussion is often a violation of federal law. The employer must engage in a good faith dialogue to figure out a solution. They don't have to give you exactly what you want. If you ask for a private corner office, they can offer noise-canceling headphones instead, but they have to offer an effective alternative. However, many employees sabotage themselves by waiting too long. They wait until they are on a performance improvement plan (PIP), to mention their depression or their back pain. While you can disclose at any time, it is tactically weaker to do it after performance issues have been documented. The employer can argue, "We are firing you for the errors you made last month, not for the disability you told us about today." The smartest move is preemptive disclosure. If you know your medication makes you groggy in the morning, request a schedule modification to start at 10 a.m. instead of 9 a.m. before you start showing up late. Let's look at the undue hardship defense. This is the shield employers use to deny accommodations. They can refuse your request if it requires significant difficulty or expense. But significant is relative to the company's resources. A request that would bankrupt a small family deli might be pocket change for a Fortune 500 company. If you work for a global conglomerate and you need a $500 ergonomic chair, their claim of undue hardship will likely be laughed out of court. They have the money, they just don't want to spend it on you. The post-2020 landscape has turned remote work into the biggest ADA battleground in history. Before the pandemic, companies argued that physical presence was an essential function of almost every job. Then the world shut down and millions of people proved they could work from home effectively. Now, if you have a disability, say an immunocompromised system or severe social anxiety, and you request remote work as an accommodation, it is much harder for an employer to claim that being in the office is essential, especially if you did the job from home for 2 years. However, you must be prepared for the medical inquiry. When you request an accommodation, your employer has the right to ask for medical documentation if the disability is not obvious. They cannot ask for your entire medical history. That is a privacy violation. They can only ask for documentation relevant to the specific condition and the specific request. You do not need to tell your boss the intimate details of your therapy sessions. You just need a doctor's note stating that you have a medical condition that limits concentration and that a quiet environment would help. Let's run a what-if scenario on mental health, which is the fastest growing category of ADA claims. Imagine you are a sales rep. You have bipolar disorder. You are excellent at sales, but the weekly RA meetings where everyone screams and shouts trigger a manic episode or severe anxiety. You ask to be excused from these specific meetings, offering to read the minutes afterwards. Your boss says, "No, participation is mandatory for team culture." If team culture is not an essential business function, meaning the business makes money without you screaming in a meeting, then the company is on thin ice. They are prioritizing a vague cultural preference over a specific medical necessity. If they fire you for skipping the meeting after you requested an accommodation, you have a potential claim for discrimination and failure to accommodate. But a warning: the ADA does not protect misconduct. If you scream at a client or punch a coworker, you cannot say, "I did it because of my disability," and expect to keep your job. The law distinguishes between the condition and the conduct. You can be fired for the conduct, even if it was caused by the condition. This is why the accommodation request must come before the explosion. You need to put the guardrails in place while things are calm. There is also the direct threat defense. An employer can deny employment if your disability poses a direct threat to the safety of yourself or others that cannot be eliminated by accommodation. A narcoleptic cannot be an airline pilot. That is a clear safety risk. But a diabetic can be a police officer, provided their blood sugar is managed. Employers often use safety as a blanket excuse to discriminate. They assume a risk exists where there is none. This is based on stereotypes, and the ADA explicitly forbids employment decisions based on myths or fears about a disability. To weaponize this right for your protection, you need an accommodation letter. It should be formal, in writing, and sent to HR, not just your buddy in the next cubicle. "I am writing to request a reasonable accommodation for a medical condition to allow me to perform my job duties effectively." You don't even have to cite the ADA legally, but using the phrase reasonable accommodation triggers the legal obligations of the HR department. They are trained to spot those words. It's like a code that switches their brain from annoyed manager to risk compliance officer. We have now secured your right to discuss pay, your right to overtime, your right to medical leave, and your right to physical and mental accommodation. You have built a fortress around your employment. But there is one final massive vulnerability. All the laws we have discussed so far govern actions: what you do, what you are paid, how you work. But what about who you are? What happens when the hostility isn't about your schedule or your health, but about your identity? What happens when the workplace becomes a psychological war zone, not because of bad management, but because of systemic bias against your race, your gender, your religion, or your age. The final pillar of workplace rights is the one that most people think they understand, but almost everyone gets wrong. It is the difference between a boss who is a jerk and a boss who is a criminal. In the next part, we are going to dissect the bedrock of civil rights in the workplace, Title VII. We will explain exactly what a hostile work environment actually is. Spoiler: it's not just a rude boss, and how to distinguish between legal bullying and illegal harassment. We are going to the Supreme Court level. Right number 5. Freedom from discrimination and harassment under Title VII. This is the bedrock of American civil rights in the workplace, yet it is also the most misunderstood. If you walk into a lawyer's office and say, "My boss is creating a hostile work environment," the first question they will ask you is not "What did he say?" but "Why did he say it?" This distinction is where most cases die. In the United States, it is not illegal to be a terrible manager. It is not illegal to be rude, abrasive, demanding, or even cruel. You can have a boss who yells at everyone, insults everyone's intelligence, and makes people cry on a daily basis. If he treats everyone like garbage equally, he is an equal opportunity jerk. And under federal law, that is often perfectly legal. The hostile work environment is a term of art, not a description of your feelings. To be actionable under Title VII of the Civil Rights Act of 1964, the hostility must be based on a protected characteristic. These characteristics are specific and finite: race, color, religion, sex, which now includes pregnancy, sexual orientation and gender identity, and national origin. We also have the Age Discrimination in Employment Act (ADEA) for those over 40, and the Genetic Information Non-Discrimination Act (GINA). If the bullying is not tethered to one of these categories, you are likely dealing with a toxic workplace, not a Title VII violation. Let's analyze disparate treatment. This is the smoking gun. It is intentional discrimination. Imagine a scenario involving two employees, James and Maria. Both are late to a meeting by 10 minutes. James, a white male under 40, is greeted with a joke. "Rough traffic today, huh, James?" Maria, a Hispanic woman over 40, is given a formal written warning for tardiness and lack of professional respect. In isolation, Maria's write-up looks like standard discipline. But when you compare it to James's treatment, a pattern emerges. This is the comparator evidence that lawyers look for. You do not prove discrimination by looking at how you were treated. You prove it by looking at how similarly situated employees outside your protected class were treated. If the rules apply to you but not to them, the at-will defense starts to crumble. But Title VII goes deeper than just obvious insults. We must discuss disparate impact. This is the silent killer of diversity. It occurs when a company has a policy that looks neutral on its face. It mentions no race or gender, but in practice, it disproportionately weeds out a protected group. Consider a logistics company that requires all warehouse managers to be at least 6 feet tall for safety reasons to reach high shelves. On paper, this is not a policy against women. It is a height policy. But statistically, this requirement will exclude the vast majority of women, while allowing most men to qualify. Unless the company can prove that being 6 feet tall is a bona fide occupational qualification, meaning it is absolutely necessary to do the job, and there is no other way to reach the shelves, like a ladder, this is likely illegal sex discrimination. Intent does not matter here, the outcome does. Now let's navigate the minefield of harassment. The Supreme Court has established that for harassment to be illegal, it must be severe or pervasive. This is a high bar. One off-color joke, while unprofessional, rarely constitutes a hostile work environment in the eyes of a federal judge. The conduct must be so extreme that it alters the terms and conditions of your employment. Severe refers to the intensity. A single instance of physical assault or a racial slur used by a supervisor can be enough to trigger liability immediately because it is so severe. Pervasive refers to the frequency. A series of microaggressions, constant comments about your hair, your accent, or your age, may not be actionable individually, but when accumulated over 6 months, they create a pattern and practice of harassment. Imagine Robert, an older employee near retirement. His manager never says, "I'm firing you because you're old." Instead, the manager starts asking, "So when are you planning to slow down?" Or, "This new software might be a bit too fast-paced for the old guard, don't you think?" Then Robert is left off email chains. Then, his accounts are transferred to a 25-year-old recent grad. This is constructive discharge. The company is making the environment so intolerable that a reasonable person would feel compelled to quit. If Robert quits, he falls into a trap. In many states, if you resign, you lose your right to unemployment benefits and your standing to sue for wrongful termination is significantly weakened. The courts often view a resignation as a voluntary choice. However, if you can prove constructive discharge, that the resignation was essentially a firing in disguise, you can still win. But the burden of proof is astronomical. This brings us to the most dangerous phase of any Title VII claim, the internal investigation. When you report discrimination to HR, you trigger a specific legal protocol. The company is required to investigate. Most employees believe this investigation is a quest for truth. It is not. It is a quest for liability mitigation. When you sit down with HR to report harassment, you are effectively serving them with a lawsuit warning. They will take notes. They will interview witnesses. But be warned, the confidentiality they promise is limited. They have to talk to the accused to get their side of the story. Let's look at the retaliation provision within Title VII. This is often easier to prove than the discrimination itself. Statistics from the Equal Employment Opportunity Commission (EOC) show that retaliation is the most frequently alleged basis of discrimination. Here is the imagine-if scenario. You file a complaint about your boss making sexist comments. The investigation concludes that it was he said, she said, and no disciplinary action is taken against him. However, 3 weeks later, you are moved to a desk next to the bathroom, and your request to attend a key industry conference is denied due to budget cuts, even though your male colleague is allowed to go. That denial is retaliation. The Supreme Court has ruled that retaliation can be any action that would dissuade a reasonable worker from making or supporting a charge of discrimination. It doesn't have to be a firing. It can be a shift change, an exclusion from meetings, or a sudden drop in performance ratings. If this happens, you have a second, often stronger legal claim. Even if the original sexism claim was weak, the retaliation claim can win millions. Why? Because juries hate bullies. They might forgive a bad joke, but they rarely forgive a company that punishes someone for speaking up. However, to access Title VII protections, you generally cannot just sue immediately. You must first file a charge of discrimination with the EEOC or your state's Fair Employment Practices Agency. This is called exhausting administrative remedies. You have a strict deadline, usually 180 or 300 days from the last incident of discrimination, to file this paper. If you wait 301 days, your rights under federal law may evaporate forever. We have now covered the 5 pillars: wages, overtime, family leave, disability accommodation, and freedom from discrimination. These are your swords and your shields. But knowing you have a sword is useless if you do not know how to swing it. Knowledge of the law is only the first step. The second and far more critical step is proof. You can be 100% right morally and legally, and still lose everything if you cannot prove it in a format that a court accepts. The biggest mistake employees make is assuming that the truth will set them free. In the legal system, the truth does not matter. Evidence matters. Most employees are currently generating evidence that hurts them, not helps them. You are sending emails that make you look insubordinate. You are having conversations in hallways that vanish into thin air. You are trusting verbal promises. In the next part, we are going to enter the evidence locker. I am going to teach you the specific forensic method of documenting your workplace reality. We will cover the concept of the contemporary note, the BCC trap, and the one specific email subject line that strikes fear into the heart of every corporate general counsel. We are moving from knowing your rights to enforcing your will. This is where we start building your case file. Welcome to the evidence locker. This is the operational phase of the masterclass. Up until this moment, we have been discussing abstract legal theories and federal statutes. Those are the rules of the game. Now we are discussing the equipment you need to win the game. The single most common reason valid employment cases fail in court, or never even make it to a settlement negotiation, is a lack of admissible evidence. In the eyes of the law, if it is not written down, it did not happen. You might have a memory of your boss screaming a racial slur at you. You might remember the exact date and time. But in a deposition 2 years from now, it will be your word against the word of a manager who has been coached by a corporate legal team. They will paint you as emotional, forgetful, or disgruntled. They will deny the incident ever occurred. This is called gaslighting. And in the legal world, it works disturbingly well unless you have a contemporaneous note. The contemporaneous note is your strongest weapon. This is a legal term for a record created at the time the event occurred, or very shortly thereafter, while the memory was fresh. Courts and juries give significantly more weight to a diary entry written on the day of the incident than to a memory recalled months later. Here is the protocol you must adopt immediately. Do not use your work computer for this. Your work computer is company property. They can keylog your strokes, they can read your drafts, they can wipe the drive remotely the moment they decide to fire you. You need a shadow log. This can be a physical notebook kept in your car or purse, or a secure, cloud-based document on your personal phone, accessed only via your personal data, never company Wi-Fi. Every time an incident occurs, whether it is a comment about your age, a denial of overtime pay, or a suspicious change in your duties, you log it. The entry must be clinical. Do not write, "My boss was a jerk today." That is an opinion. Write, October 14th, 2:30 p.m. Location: break room. Manager John Smith approached me and stated, quote, "We need someone with more energy for this role, maybe someone younger." End quote. Witnesses present: Sarah Jenkins and Mike Ross. This level of specificity transforms a feeling into a fact pattern. When you present a lawyer with a log containing 20 distinct entries, complete with dates, times, and quotes, you are no longer a risky client. You are a formidable adversary. Now let's talk about the confirmation email. This is the maneuver that catches slippery managers. Managers who violate the law often prefer to do it verbally. They will pull you into a room, close the door, and say, "We aren't going to pay you for that travel time." Or if you take FMLA, don't expect a promotion. They know that without a paper trail they are safe. You are going to strip them of that safety using the "just to clarify" tactic. Immediately after a verbal conversation where something questionable was said, you go back to your desk and send an email. The subject line should be neutral. Recap of our discussion. The body of the email should read, "Hi, thanks for meeting with me earlier. I just want to make sure I understood our conversation correctly to ensure I am in compliance. You mentioned that I should not log the hours I spent traveling to the client site on Saturday, and that this time is unpaid. Please let me know if I have misunderstood." You have just set a trap. They now have two choices. Choice A. They reply and confirm the illegal instruction in writing. You now have a smoking gun for a wage theft claim. Choice B. They realize they are being documented and they panic. They might reply, "No, that's not what I meant, go ahead and log it." In that case, you just got paid. Choice C. They ignore it. If they ignore it, your email stands as the only written record of the conversation. In court, an unrebutted confirmation email is powerful evidence that the conversation happened exactly as you said it did. However, we must address a critical danger zone: the BCC trap. Many employees try to save evidence by blind carbon copying BCC, their personal email address on work correspondence, or by forwarding documents to themselves. This is extremely risky. Most modern data loss prevention (DLP) software flags auto-forwarding or large attachments sent to external domains like Gmail or Yahoo. If you forward a document that contains confidential information, client lists, or trade secrets to your personal email, you have just given the company a legal reason to fire you for cause. They can sue you for theft of proprietary information. They will use your data breach to distract from their discrimination. The rule is simple. You can generally document your own experiences and communications regarding your employment terms, but you must never steal company property. Do not forward client databases. Do not forward strategic plans. If you need to save an email that proves harassment, the safest method is often to print it to PDF and save it to a personal USB drive, if USB ports aren't blocked, or if necessary, take a photograph of the screen with your personal phone. A photo of a screen is low-tech, but it is hard to track and harder to refute. Now let's discuss the nuclear subject line. I promised you the subject line that strikes fear into general counsels. Most employees, when they complain to HR, use subject lines like "complaint" or "unfair treatment" or "my boss." These are weak. They sound like interpersonal drama. HR often ignores drama. You need to shift the language from personnel issue to liability risk. The subject line you use is formal grievance, protected activity/notification of hostile work environment. When a certified HR professional sees the words protected activity and hostile work environment in a subject line, their heart rate goes up. These are legal trigger words. Protected activity implies you are exercising a right under the EEOC or DOL statutes. By using this specific phrasing, You are signaling that you know the law. You are signaling that any action they take against you after this email could be construed as retaliation. In the body of this email, you do not rant. You reference your shadow log. You state, I am reporting a pattern of behavior that appears to be discriminatory based on the following dates, X, Y, and Z occurred. You then end with a specific call to action. Please consider this a formal notification. I am requesting a prompt investigation into this matter to ensure a safe, compliant work environment. This forces them to open a file. They cannot claim ignorance later. You have put them on notice. But what about recording? We live in an era where everyone has a microphone in their pocket. Why not just record the meeting? This is where the one-party versus two-party consent laws destroy careers. The United States is a patchwork of wiretapping laws. In one-party consent, states like Texas, New York, or Georgia, only one person in the conversation needs to know it is being recorded. That person is you. You can secretly record your boss legally. However, in two-party or all-party consent, states like California, Florida, or Massachusetts, it is a crime to record a private conversation without the consent of everyone involved. If you secretly record a meeting in California, not only is that evidence inadmissible in court, but you could also face criminal charges and be sued by the person you recorded. Furthermore, even in one-party states where it is legal, it is almost certainly against company policy. If you are caught recording, you can be fired for violating the code of conduct. So, while the recording might save your lawsuit, it will cost you your job. You must weigh that risk. If you are already planning to leave and just want a settlement, the recording might be leverage. If you want to stay, it is a dangerous gamble. There is a safer alternative to audio recording: the witness strategy. If you are called into a disciplinary meeting, ask, "Can I bring a coworker or a witness to sit in?" If you are in a union, this is your Weingarten right. If you are not in a union, they can say no. But if they say no, you document that refusal. I asked for a witness and manager X refused. That refusal makes them look like they have something to hide. We have now built your dossier. You have the knowledge of your rights. You have the shadow log of evidence. You have the confirmation emails creating a paper trail. You have avoided the traps of data theft and illegal recording. You are sitting on a pile of leverage. But leverage is kinetic energy. It does nothing until you release it. The question now becomes, how do you use this information to get what you actually want? Do you want to keep your job and fix the culture? Or do you want to hit the eject button and walk away with a 5-figure severance check to bridge the gap to your next career move? Most people think severance is only for layoffs. They are wrong. You can negotiate your own exit. You can fire your employer and make them pay you to leave. In the next part, we are going to teach you the art of the strategic exit. We will dissect the severance agreement. We will explain what a general release of claims is and why you should never ever sign it on the first day. We are going to turn your legal leverage into cash in the bank. Welcome to the negotiation table. This is the moment where the rubber meets the road. You have navigated the complexities of your employment. You have documented the infractions, and now you are facing the exit. Whether you are being laid off, fired, or you are choosing to leave a toxic environment, there is often a document waiting for you at the end of the road. It is usually titled Separation Agreement and General Release. Most employees view this document as a receipt. They think, oh, this is just the paperwork to get my final check. Or worse, they view the severance payment as a generous gift from the company to help them transition. This is a dangerous misconception. Corporations do not give gifts. They buy assets and they mitigate liabilities. When a company offers you severance, they are not paying you for your past service. That is what your salary was for. They are paying you for your future silence. They are buying your right to sue them. You need to understand the mechanics of the general release of claims. This is the heart of the severance agreement. It is usually a dense paragraph, written in all capital letters, that lists every single federal and state employment law in existence. It will say that you knowingly and voluntarily release the company from any claims arising under Title VII, the ADA, the FMLA, the ADEA, and a dozen other acronyms we have discussed. By signing that line, you are legally stating, I agree that you did nothing wrong, and even if you did, I will never take you to court over it. If you have a valid claim for sexual harassment, and you sign that paper for 2 weeks of pay, your claim is dead. You sold a potentially 6-figure lawsuit for $1,000. This is why you never ever sign a severance agreement in the room where it is presented. HR managers are trained to use pressure tactics. They might say, "This offer expires at 5 p.m. today," or "You need to sign this before you leave the building to get your check." In many cases, these are bluff tactics. For employees over the age of 40, this pressure is actually illegal under a specific federal statute called the Older Workers Benefit Protection Act, or OWBPA. The OWBPA is a critical shield for older workers. It mandates that if you are over 40, the employer must give you at least 21 days to review the agreement. You have a federal right to take that document home, sit with it for 3 weeks, and show it to a lawyer. If they force you to sign it on the spot, the waiver might be invalid in court. Even if you are under 40, standard legal practice usually allows for a reasonable review period, typically 5 to 7 days. If they are pressuring you to sign instantly, that is a red flag that they are terrified of what you might know. Now let's talk about how to use your shadow log and your knowledge of rights to increase that number. This is the art of the strategic exit. Immagine a scenario. You are being let go. They offer you 4 weeks of severance. You have a documented history of unpaid overtime, Part 3, and a potential FMLA violation, Part 4, in your shadow log. You do not sign the agreement. Instead, you, or preferably your attorney, send a letter. The letter does not scream, "I am suing you." It invites a conversation. It says, "I have reviewed the severance agreement. However, I believe the current offer does not adequately reflect the potential claims I would be waiving. Specifically, I have concerns regarding unpaid overtime wages from 2023 and the procedural handling of my medical leave." You have just put a price tag on their risk. The company's legal counsel will look at your claim. They will calculate the cost of defending a lawsuit. Even a winning lawsuit costs a company $50,000 to $100,000 in legal fees. If asking for an extra $20,000 in severance makes you go away quietly and sign the release, that is a rational business decision for them. This is called cash for peace. You are not being greedy. You are negotiating the value of the legal rights they are asking you to destroy. However, money is not the only currency on the table. You must look at the non-monetary terms. The most dangerous clause outside of the release is the non-disparagement clause. This clause effectively gags you. It says you cannot say anything negative about the company, its products, or its officers forever. In the age of social media, this is a heavy burden. If you post a negative Glassdoor review 3 years from now, they could sue you for breach of contract and demand the severance money back. If you must sign a non-disparagement clause, you should fight for mutuality. A standard agreement is one-sided. You can't talk bad about them, but they can trash you to future employers. You want a clause that says, "The company agrees to instruct its officers and directors not to make disparaging statements about the employee." This ensures a ceasefire on both sides. Furthermore, look at the neutral reference provision. If you are fired, you are terrified that your old boss will sabotage your next job application. You can negotiate a clause in the severance agreement that dictates exactly what HR will say when a potential employer calls. Usually, this is limited to dates of employment and title held. This is called a neutral reference. It protects your career future. You can even negotiate for them to agree not to contest your unemployment benefits. Let's touch on that. Unemployment insurance. This is a state-run benefit, but your former employer has a say in it. If they tell the state you were fired for misconduct, your claim will likely be denied. If you resign voluntarily, your claim is usually denied. In your severance negotiation, you want the agreement to characterize the separation as a resignation for good reason or a mutual separation. You want them to agree in writing that they will not contest your unemployment claim. While the state makes the final decision, having the employer's cooperation removes the biggest hurdle. Consider the rehire status. Some severance agreements include a no rehire clause, meaning you are banned from ever working for that company or its subsidiaries again. If you work in a specialized industry where this company owns half the market, or if they are acquired by a giant later, this could accidentally blacklist you from half the jobs in your field. You need to be aware of how wide that net is cast. There is a new trend you must be aware of: the NLRB's crackdown on restrictive severance. In 2023, the National Labor Relations Board issued a decision, McLaren-McComb, suggesting that broadly written non-disparagement and confidentiality clauses might violate the National Labor Relations Act because they prevent employees from discussing working conditions. This is a developing area of law, but it gives you leverage. If their non-disparagement clause is overly broad, you can point out that it might be illegal under current NLRB standards. Let's walk through the walk-away number. You need to know your bottom line. If the company refuses to negotiate, if they offer you peanuts for a waiver of serious civil rights violations, you have to make a choice. Do you sign the paper and take the quick cash? Or do you refuse to sign, keep your rights, and initiate a legal battle? This is the precipice. Many people threaten to sue. Very few people understand what that actually means. They have a cinematic view of the legal system. A dramatic courtroom scene, a tearful confession, and a gavel banging in their favor. The reality of litigation is a meat grinder. It is invasive, expensive, and psychologically exhausting. It involves turning over your private text messages, your social media history, and your medical records to the company's lawyers. It involves sitting in a conference room for 8 hours while opposing counsel tries to trick you into admitting you are a liar. If the negotiation fails and you decide to pull the trigger on a formal lawsuit, you are leaving the world of HR policy and entering the world of federal civil procedure. The rules change completely. The timeline stretches from weeks to years. In the next part, we are going to demystify the litigation lifecycle. We will explain what actually happens when you file a charge with the EEOC. We will talk about discovery, the phase where they dig into your past, and mediation, the room where 95% of these cases actually end. We are going to show you the ugly, unvarnished truth of suing a corporation, so you can decide if the war is worth the price. Welcome to the litigation lifecycle. This is the chapter where we dismantle the Hollywood illusion of justice. You have likely seen movies where the underdog employee marches into a courtroom, delivers a passionate speech, and the jury gasps as the evil CEO hangs his head in shame. That is fiction. The reality of suing a corporation in the United States is a war of attrition. It is slow, it is expensive, and it is designed to break your spirit long before you ever see a jury box. If you decide to reject the severance and fight, you do not simply walk into a courthouse the next day. For most federal claims, specifically those involving discrimination under Title VII, the ADA, or the ADEA, you must first navigate a mandatory administrative purgatory known as the Equal Employment Opportunity Commission, or EEOC. You cannot file a lawsuit in federal court until you have exhausted administrative remedies. This means you must file a formal charge of discrimination with the EEOC. This is a critical juncture where time is your enemy. In many states, you have only 180 days from the date of the incident to file this charge. In states with their own local agencies, this is extended to 300 days. If you wait 301 days, your federal rights are extinguished. The door is locked, and no lawyer can open it. Once you file, the EEOC notifies your employer. The company then files a position statement. This is a document, written by their high-priced legal team, that tells their version of the story. They will paint you as incompetent, insubordinate, or delusional. They will cherry-pick every mistake you ever made. You will read this document and you will feel a surge of rage. You will want to scream. That is a lie. You will have the chance to submit a rebuttal. But you must understand that the OC investigators are overworked. They have caseloads in the hundreds. They are not CSI detectives. They are bureaucrats pushing paper. Often, after months or even years of investigation, the EOC will issue a dismissal and notice of rights, commonly known as a right to sue letter. This does not mean you lost. It simply means the EOC has decided not to pursue the case themselves, but they are giving you permission to proceed on your own. Once that letter hits your mailbox, a new countdown begins. You have exactly 90 days to file a lawsuit in federal court. If you file on day 91, your case is thrown out. Now you enter the discovery phase. This is the digital autopsy of your life. This is the part that no one warns you about. In a civil lawsuit, both sides are entitled to any information that could be relevant to the claims or defenses. The company's lawyers are going to tear your life apart to find something, anything, to discredit you. They will subpoena your medical records. If you are claiming emotional distress damages, they are entitled to read your therapy notes. They will read about your childhood trauma, your marital problems, and your anxieties that have nothing to do with work. They will use this to argue that your stress wasn't caused by the hostile work environment, but by your divorce or your difficult childhood. They will try to humiliate you into dropping the case. They will demand your social media history. They will scrape your Facebook, your Instagram, your Twitter. Remember that post from 3 years ago where you looked a little too intoxicated at a party? They will blow that up on a projector to suggest you are irresponsible. Remember when you vented to a friend via text message? They might get those texts. If you complained about your boss but also admitted to slacking off in a private message, that is now Exhibit A for the defense. Then comes the deposition. This is the psychological breaking point for many plaintiffs. You will be placed in a conference room under oath with a court reporter typing every syllable you speak. Across the table sits the company's defense attorney. Their job is to trap you. They will ask you the same question 5 different ways to see if your story shifts. They will ask open-ended questions to get you rambling, hoping you slip up. They will ask, "Have you ever lied?" If you say no, you are a liar because everyone has lied. If you say yes, they will ask, "So you admit you are capable of dishonesty?" It is a game of 4D chess, and you are playing against a grandmaster. A deposition can last 7 or 8 hours. It is exhausting. You will leave that room feeling battered. During this entire process, you are also facing the duty to mitigate. You cannot simply quit your job, sit on the couch, and wait for a payout. The law requires you to actively look for new employment. If you win your case, the company owes you back pay, the money you lost between being fired and the trial. However, if they can prove you didn't try to find a new job, the judge will cut your damages to 0. You have to keep a log of every job application, every interview, and every rejection. You have to prove you tried to stop the financial bleeding. Furthermore, you need to know about the after-acquired evidence doctrine. While digging through your past, suppose the company finds out that you lied on your resume 5 years ago. Maybe you claimed a degree you didn't finish. Even if that had nothing to do with why they fired you, they can use that lie to limit your damages. They will argue, "If we had known about this lie back then, we would have fired them anyway." This can destroy your potential payout. So, how does this actually end? Statistically, it does not end with a jury verdict. Over 95% of employment cases settle before trial. They end in mediation. Mediation is a process where a neutral third party, often a retired judge, shuttles back and forth between 2 rooms. You and your lawyer are in one room, the company and their lawyers are in another. You never see them. The mediator comes to you and says, "Look, they are offering $50,000. I know you want $1 million, but here are the weaknesses in your case." Then he goes to the other room and scares them about the jury verdict. This is shuttle diplomacy. It is a cold, transactional calculation. The company is not admitting guilt. They are calculating the cost of defense. If it will cost them $150,000 to take this to trial, and they can settle with you for $75,000, they will write the check to save money. It is not about justice. It is about the balance sheet. If mediation fails, you face the final boss. Summary judgment. Before a trial can happen, the company will file a motion asking the judge to dismiss the case entirely. They will argue that even if everything you say is true, it doesn't legally count as discrimination. Judges, who are often conservative in their interpretation of the law, grant these motions frequently. If the judge grants summary judgment, your case is dead. You get 0. You have spent 2 years of stress for nothing. However, if you survive summary judgment, the dynamic flips. Suddenly, the company is terrified. Now they are staring down the barrel of a public trial. This is when the settlement offers often double or triple. They do not want their executives cross-examined in public. They do not want the bad PR. But you have to ask yourself, is it worth it? The litigation tax is not just the 33% or 40% contingency fee your lawyer takes. It is the years of your life where you are reliving your worst trauma. It is the sleepless nights. It is the fact that future employers might Google your name and see the lawsuit. While it is illegal to blacklist you, in reality, many hiring managers avoid candidates who have a history of suing employers. It is a scarlet letter. This is why the strategic exit we discussed in Part 8 is so vital. A negotiated severance package gives you closure now. Litigation keeps the wound open for years. But let's zoom out. Everything we have discussed in this series, the 40-hour workweek, the right to organize, the protections against discrimination, is based on a 20th century model of employment. It assumes a human being working for a human boss in a physical building. That model is dying. We are standing on the precipice of the greatest shift in labor history since the Industrial Revolution. The new threats to your livelihood are not just bad managers, they are algorithms. They are gig economy loopholes that classify you as a contractor to strip you of every right we have just fought for. They are artificial intelligence systems that decide who gets hired and fired without a human ever reading a resume. The laws we have discussed are struggling to keep up. The FLSA was written for factory workers, not Uber drivers. Title VII was written before AI began conducting job interviews. The next frontier of workplace rights is not about overtime. It is about data dignity and algorithmic accountability. In the final part of this masterclass, we are going to look forward. We are going to explore the future of work and the new emerging rights you need to fight for in the age of AI. We will discuss how to protect yourself when your boss is a piece of code, and how to future-proof your career against the obsolescence of the human worker. The rules are changing, and if you are playing by the old book, you have already lost. Welcome to the era of the invisible boss. We are witnessing the extinction of the manager as you know it. For decades, workplace friction was interpersonal. You argued with a supervisor, you negotiated with a director, you complained to HR. Today, and increasingly in the coming years, your supervisor is not a human being. It is an algorithm. It is a line of code hosted on a server 3,000 miles away, and it controls your livelihood with a cold mathematical ruthlessness that federal law is currently powerless to stop. This is the frontier of algorithmic management, and it is the single greatest threat to worker rights in the 21st century. We have spent this entire series discussing laws like Title VII and the ADA, laws that were written to govern human behavior. But how do you sue a piece of software for discrimination? How do you prove intent when the decision maker is a black box neural network that not even its creators fully understand? Imagine a scenario. You apply for a job. You have the perfect resume, the right degree, and 10 years of experience. You upload your PDF to the company portal. 0.3 seconds later, you receive a rejection email. No human eyes ever saw your application. An artificial intelligence hiring tool scanned your document, compared it to the profiles of the company's current top performers, and decided you were not a match. Why? Maybe the AI noticed a 6-month gap in your employment history from 3 years ago. A gap caused by your FMLA-protected medical leave. The AI doesn't know what FMLA is. It just sees a statistical correlation between employment gaps and lower retention rates. So it filters you out. This is algorithmic bias. It creates a disparate impact that is nearly impossible to prove because the company will claim, "We didn't discriminate. The computer just gave you a low score." Or consider the rise of bossware. As remote work became normalized, corporations panicked about losing control. Their solution was digital surveillance on a scale previously reserved for espionage. Companies are now deploying software that takes screenshots of your desktop every 10 minutes. They use keystroke loggers to measure your typing speed. Some even use webcam access to track your eye movements to ensure you are looking at the screen. If you are an hourly employee, and you stop typing for 5 minutes to use the restroom, the software marks you as idle. At the end of the week, if your idle time exceeds a certain threshold, you are automatically disciplined. There is no manager to explain the situation to. The data is the judge, jury, and executioner. In many states, this invasiveness is perfectly legal. The Electronic Communications Privacy Act, passed in 1986, allows employers to monitor communications on their own devices and networks. If you are using their laptop, you have almost no expectation of privacy. This leads us to the gigification of the workforce. We discussed the difference between employees and contractors in Part 3, but the gig economy has weaponized this distinction. Companies like Uber, DoorDash, and TaskRabbit built entire empires on the premise that their workers are not employees, but independent entrepreneurs. By classifying you as a 1099 independent contractor, they strip you of every single right we have discussed in this masterclass. Minimum wage? Gone. Overtime pay? Gone. FMLA? Gone. Unemployment insurance? Gone. The right to unionize under the NLRA? Gone. You are unprotected. The freedom they sell you is the freedom to starve if you get sick. However, the tide is turning. The Department of Labor in states like California and New York are fighting back with legislation to reclassify these workers as employees. This is a legal war zone. If you are working a gig job, you need to watch these court cases closely, because your status could flip overnight, suddenly entitling you to thousands of dollars in back benefits. We must also discuss the battle for data dignity. If you work in a creative field, copywriting, graphic design, coding, you are currently training your replacement. Every time you write a report or design a logo, that data is potentially being fed into a generative AI model owned by your employer. They are harvesting your expertise to build a model that can do your job faster and cheaper. There is currently almost no legal framework preventing an employer from using your past work to train an AI to fire you. This is why the writers and actors unions in Hollywood went on strike in 2023. They weren't just fighting for money. They were fighting for an existential clause in their contracts to prevent AI from simulating their performances. This is the future of collective bargaining. It's not just about more money. It's about human exclusivity. So where does this leave you? You now possess the knowledge of the old guard laws, wages, leave, discrimination, and you are aware of the new guard threats, surveillance, AI, and gigification. Your strategy must be twofold: enforcement and adaptation. First, enforcement. Rights are not self-executing. The Fair Labor Standards Act does not magically put money in your bank account. The ADA does not magically build a ramp. These laws are merely tools lying on a table. They do nothing until you pick them up and use them. You are the enforcement mechanism. When you document a violation in your shadow log, you are enforcing the law. When you send a just to clarify email, you are enforcing the law. When you refuse to sign a lowball severance agreement, you are enforcing the law. Second, adaptation. You must future-proof your career against the single point of failure. The days of working for one company for 30 years and retiring with a gold watch are dead. In a world where an algorithm can lay off 10,000 people via email at 3 a.m., relying on a single source of income is a risk you cannot afford. You must adopt the portfolio career mindset. Even if you have a full-time job, you need to view yourself as a business that happens to have one major client. Diversify your skills. Understand how AI impacts your specific industry, and learn to wield it before it wields you. And perhaps most importantly, look at the resurgence of unions. For decades, union membership in the US declined. Now it is spiking. From coffee shops to warehouses to tech companies, workers are realizing that an individual standing against a trillion-dollar algorithm loses every time. But a collective can halt the algorithm. Unions are the only entities moving fast enough to negotiate protections against AI surveillance and automated firing. If your workplace is becoming a digital sweatshop, the solution might not be a lawsuit. It might be an election. We have reached the end of this deep dive. We started with the disclaimer that this is not legal advice, and we end with the reality that this is survival advice. The corporate landscape is designed to extract maximum value from you for minimum cost. That is its nature. Your nature must be to protect your value, your time, and your dignity with ferocious intelligence. Do not be the employee who gets blindsided. Be the employee who knows the handbook better than HR. Be the employee who keeps the receipts. Be the employee who knows that at will does not mean without rights. You have the roadmap. You have the tactics. You have the mindset. The rest is up to you. If you found value in this masterclass, if this series saved you money or saved your sanity, you know what to do. Share this with a coworker who is struggling. Share it with a friend who just got fired. Knowledge is the only leverage that multiplies when you give it away. Stay vigilant. Stay documented. And never ever sign on the first day.